to them, the conditions that defendants argue will make it a challenge to select a jury will not appreciably change after the completion of the election. The last line of Jack Smith's filing says, "For all of these reasons, the court should reject defendants' invitation to defer consideration of a trial date and should set jury selection to begin on December 11th, 2023. Leading off our discussion tonight, Andrew Weissman, former FBI General Counsel and former Chief of the Criminal Division in the Eastern District of New York. He's a professor of practice at NYU Law School. Also with us, Glenn Kirshner, former federal prosecutor. He is the host of the Justice Matters podcast. They are both MSNBC legal analysts. Andrew Weissman, your reading of Jack Smith's response on scheduling.
Well, we anticipated that he was going to file a response because so far he's really sort of run this crack team of making sure that his position is known to the court and the court has the benefit of his thinking. I thought was a very strong brief. The borderline frivolous line is in reference to something that's important. The former president keeps on talking about the Presidential Records Act and keeps saying that's what governs this case. And that is what the government took direct aim at and said it is entirely irrelevant to this criminal case, both to the retention of classified national defense information part of the case and to the obstruction case. And so I thought it was really good that they just took aim at that. What they basically said was frivolous, I think they were a little more polite and said borderline frivolous. And then I think the other thing worth noting is it is really important for people to understand this is not a voluminous document case. You know what a voluminous document case is? Enron, where the words terabyte come up when you're dealing with huge amounts of electronic data. It is true that this is not a sort of like a car crash. It's not something which is a very small case, but it just is not that complicated. The biggest issue here is the classified documents, and I think it's good that the government conceded that will take some time, but their point is that this will be 6 months. There is ample time for people to go through that material because it's not that much. So there's a very strong brief. It'll be a real test of Judge Cannon as to what she does at this point, whether she really is going to be fair to the government in their request for a firm trial date.
Glenn Kirshner, as I said on this program, when I read the Trump lawyers' request for the continuance, it made sense to me when they were talking about the massive nature of the discovery here, but they left out an awful lot of specifics about that the government has now supplied for us. And of course, I didn't think it made sense that they should have an indefinite continuance, but certainly an argument for a continuance was in there in the amount of material. The government, Jack Smith says, as we just said in this document, that we have, in effect, given you defense lawyers a study guide. We've pointed out to you what the highlights are in this massive amount of material. But from the Trump lawyer perspective, how can they trust or rely on or use effectively a study guide that's supposed to save them time supplied to them by the prosecutors?
You know, Lawrence, you just made the exact point that will be made by the defense attorneys. You know, thank you very much, prosecution team, for helpfully pointing out, for example, what portions of the surveillance video you believe are relevant to the case. That doesn't mean we're going to agree with your assessment. But, Lawrence, I love your characterization of this 10-page filing. You said Jack Smith hit back hard. I would agree with Andrew. This is a persuasive court pleading. It is a model of clarity, of brevity, of persuasion. It is only 10 pages, double-spaced. It's a quick, easy read. I would urge people to read it because it is clear. Jack Smith and his team don't mince words. They don't pull punches. And I was really kind of excited when I read it because it feels like a sign of the prosecution to come, and I think that they are going to continue to insist on a timely trial date. And in fact, on page 1 of this pleading, they highlight how the Trump defense team failed in really its most important endeavor when they filed their pleading on July 10th. They said, Judge, don't set a trial date. One of the first things Jack Smith pointed out is the Speedy Trial Act says the judge shall set a day certain for the trial to begin. So they really just sort of embarrass the Trump defense team's request, and they don't let up for the 10 pages. So I am encouraged that this is what we can expect from Jack Smith and his team.
Yeah, Andrew Rice, but I agree with Glenn.